Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the powers of the CIT appeal while disposing of an appellate order by the CIT appeal. The issue before the Honorable Delhi High Court was that if the CIT appeal by using its power, that is equivalent to coterminous power of the assessing officer, collect some information from the assessee or from the assessee's bank, and on the basis of that information the CIT appeal finds that the notice issued to the assessee was on incorrect facts, and after analyzing all the information the assessing officer finds that whatever the findings have been given by the assessee by the assessing officer were factually incorrect. So whether in that case the CIT appeal can pass his order on the basis of information collected by him without giving an opportunity to the assessing officer to comment on that. This issue has been taken up by the Honorable Delhi High Court in the case of Commissioner of Income Tax International Taxation versus Hotchand, Techchand, Punjabi. This case is reported in 483 Ι.Τ.Α at page number 486. And the date of the judgment is 6th December 2023. The present case relates to the assessment year 2012-13, and the assessing officer issued a notice to the assessee for making the assessment under section 147 by alleging that there are unexplained investments in time deposits by the assessee to a tune of rupees 16.86 crore. The assessee was not able to comply with the notices, and due to which the assessment by making a huge addition of 16.86 was made to the income of the assessee. The assessee filed the appeal before the CIT appeal, and when the CIT appeal was examining the appeal of the assessee, the CIT appeal called various information from the assessee and also the bank statement and various information collected through the bank of the assessee through the assessee. After analyzing that information, the CIT appeal found that the amount alleged on the assessee was 16.86 crore as a term deposit into the bank of the assessee, while the actual term deposit was 9.5 crore. So first of all, the demand or the addition of the assessee was reduced from 16.86 crore to 9.5 crore by this factual mistakes by the assessing officer. Then the CIT appeal, after making the inquiry, found that the assessee has earned this amount of rupees 9.5 crore which has been deposited as time deposits from the out of remittances which has been received by the assessee from the United States of America over a period of time from his past earnings over a period of time. So the source of this investment was also satisfied by the assessee by the explanation that out of overseas remittances from the income of the assessee earned by him as a resident of United States over a period of time. So the CIT appeal on these findings deleted the demand of the assessee, and when the matter was before the tribunal also held that the CIT appeal has coterminous power with the assessing officer, so he was justified in deleting the addition made by the assessing officer. When this matter was before the High Court, because the department carried his appeal to the High Court, the court said that in the present case the inquiry by the CIT appeal revealed a grave factual error in recording the reasons, and because the term deposits were only to the tune of rupees 9.5 crore in spite of 16.86 crore, and the court also said that the CIT appeal has returned a finding with regard to the source of the funds of the FDs made into the bank account, which has been confirmed by the tribunal. So on these facts, the order passed by the CIT appeal, which has been confirmed by the tribunal, cannot be interfered with. So friends, the submission of the revenue that the CIT appeal has not given the opportunity to the assessing officer for making his comments will not work here, because the notice has been issued on factual errors, and more or less the CIT appeal has co-terminus power with the assessing officer to make various inquiries. So the deletion of the additions by the CIT appeal were justified. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax International Taxation versus Hotchand, Techchand, Punjabi, and this case is reported in 483 Ι.Τ.Α. at page number 486, and the date of the judgment is 6th December 2023. Thank you, friends.